Good afternoon to everybody. Can you hear me?
Yes.
Okay. Just to sort of recap what we were discussing yesterday, and that is the role of international law in not only in shaping the sort of the global relationship between the states that are in the globe, but also in shaping domestic law, and to what extent legal systems are more or less open to international law, and therefore absorb the influence of values, principles, partitions, and somehow solutions that are given by international law. So to what extent a system is open or is less open. No system is entirely closed, but obviously what varies is the more or less openness to international law. Now, what we shall try and do now is to show how not only from in the international sort of arena, there is a lot of materials that come from in international treaties, international conventions, but also there are other ways through which one can find some way of making the system work at a global level. Just to point out this fact, which is not irrelevant and which you should take into consideration. When international law becomes an object of academic and scholarly research, that is more or less in the 19th century, at the sort of the second half of the 19th century, on the whole, it is quite simple because the states that are somehow involved in this process are not many. We have obviously Europe, but Europe is, you must consider that at the second half of the 19th century, we have these two huge empires, the German Empire and the Austrian Empire, which occupy great part of Central and Central Eastern Europe. And then we have these colonial empires, Great Britain, France, and Spain has mostly finished its colonial rule, but most of Africa is still under colonial rule. And then we find, obviously, the Turkish Empire is still there. That means that most of the Middle East and Northern Africa still is partially under the control of the Turkey, of the Ottoman Empire. And then we find, if we go in the Far East, well, we find Japan, but we don't find very much. And then we find, obviously, the US, United States of America, and Latin American countries. So on the whole, we're talking about sort of 50 states, maybe not more than that, that are really important in the international arena. So making international law in when it starts is not so complicated, so difficult. You have to find an agreement between a relatively limited number of states. Now that you have to multiply by 4 that number, so it's more or less 200 states, well, you realize that international law becomes much more complex. So just to point out that why sort of it is important we keep an eye on international law and how it influences various legal systems. Now, what we'll do now is, sorry, just let me go, if I can manage, sorry, to put the slides here. Now those are there. Now let's go share screen. Okay. Can you see the slides?
Yes. Yes.
Then, as I was mentioning, international law, and I'll focus this today when we're looking at international organizations, becomes an instrument of global governance, and it is somehow strongly influenced by serious political theories. This happens with all branches of law, whether we look at criminal law, private law. Well, obviously the attitude towards, well, the role that criminal law must play in a society, or the role that private law must play in a society, and what is the extent of private autonomy, or to the contrary, what is the extent of state regulation. Well, obviously this influences a lot the shape of aspects of the law. So also international political theories have an important role in somehow directing international law in one way or another. Now, I would like to focus on another aspect. You must remember that lawyers have been mostly in the European continent, but not only, also obviously also in the Americas, have been mostly somehow in the sort of behind the rulers of the world, of the Western world. Lawyers have always been there shaping the law, making the law, and somehow directing the law according to obviously what were the indications that came from the sort of the institutions, the governing parliament rather than the executive. Now, one of the ideas that came out mostly in the mid second half of the 19th century was this idea that one really could try to unify the law. So as the world wasn't so big from a political point of view, in the sense that the countries that were there were not all as so many, I already mentioned, more or less 50. And if you look, all Latin America was more or less very much influenced by sort of French view, at least for what concerns private law and commercial law. And then Europe was also there, strongly influenced by French law, post-Napoleonic framework. Well, the idea was, why don't we unify the law? And so we see that in the 19th century, second half mostly of the 19th century, and let's say the first half of the 20th century, there's the idea that if you unify, if the legal words and concepts are the same, well, the law is the same. Now, this is a very formalistic approach, which looks only at the words of the law and just thinks that if you write a word, it means that it has the same meaning, legal meaning, in any system. Comparative law is there to dispel this fallacy and to try to explain that the same word may have in a different legal system a different meaning, although the word is exactly the same. The typical example is you use property English law and you use propriété or proprietà or in Italian or propiedad in Spanish, well, they are different, they have different meanings, especially property is something significantly different from the word that is exactly the same from an etymological point of view in continental Europe. So just to point out that this is comparative law helps point out that, well, words are important. The law is a linguistical convention because we all agree that when we say a certain word, use a certain word, we mean something that is very precise. And if it isn't precise, it isn't legal. But we are also aware of the fact that words change according to the context in which they are used. And this context, obviously for a lawyer, is the legal system in which these words are used. So what happened mostly in the sort of end of the 19th century and the first half of the 20th century, the idea of using international conventions, international treaties, in order to create a universal legal order. So this idea was very much to do, had very much to do with an utopian view of organizing the world, and you thought that you could, if you had international conventions to which all countries agreed, whether it was Argentina or Japan, well, then there was unification of the law, and then the legal systems were the same. Now, this is something that is completely wrong because, as I mentioned yesterday, closing the lesson, in all countries we have traffic lights, and traffic lights are exactly the same. The rules that apply to traffic lights are exactly the same, the Vienna Convention of 1968. So there's no doubt about that, that the words are exactly the same. However, the way people interpret these traffic lights is somewhat different. I mean, in many countries, when the yellow light turns on, everybody stops. And in other countries, instead, it is, for example, Italy, when the yellow light turns on, well, it is an encouragement to go faster and to cross the past the crossing before the light turns red. So you see, this is just to show how social habits and social behavior tend to interpret a very simple rule in different ways. So what has happened? We have substantially sort of somehow put aside in these mostly in these last 50 years, the idea of unification of the law, because we have realized that it is very difficult to unify the law all around the world using the same text, because the background, the legal mentality, the framework in which these laws are inserted is different, and you cannot change that historical, economic and social background in which that piece of legislation is inserted. And we have been moving towards much more a much more flexible approach. The idea that if we want to try not to unify, but to somehow get together, approach, converge legal systems, well, it is not through international conventions, but through this other form, which are called uniform laws. What do we mean by uniform laws? So first of all, they are non-binding texts, which are offered to states and to the private parties to shape their legal systems and their legal relations. So what you do, you say, listen, I have framed, and we shall see who frames these texts, I've done this model law, which somehow gives some ideas which you could follow, obviously adapting them to your own legal system. So it is not an international convention, which obviously requires an enormous amount of time. If we look at certain international conventions, they take, well, 10, 15 years before they are actually completely drafted and then finally signed and ratified by the countries. So the idea is that of saying, well, we'll offer a non-binding text, and then each country can choose somehow to follow this model if it feels that this model is appropriate. Now, so what we see is it is uniform laws are very common in the United States in all those areas where the states of the United States are autonomous. They have sovereignty on that, on their choices. So what they do is, as you cannot, the Congress cannot impose rules in certain areas which are belong to the states, to the single states. What happens? They are some kind of institutions that propose model laws which then the states, the single states, can adopt. Here I'll make the best example is, sorry, let's see if I can get on to the, sorry. I can get on to the, sorry, I'm trying to get on to the, here we are, message. So, now, well, obviously I made a typo here. It's uniform, sorry, it's Uniform Commercial Code, which is, we generally call it the UCC. And there's this American Law Institute, which is a private institution, which promotes these model laws in various areas of the law where the states have complete autonomy, therefore they can choose whatever they model they want. And this so-called Uniform Commercial Code, which isn't really a code, it is a very short, compared to our continental European codes, it is a pretty short text and covers only limited areas of commercial and consumer transactions. Well, but anyhow, this was something that was promoted, and finally all US states adopted it, except Louisiana, that had its own, being a system which has this French tradition. Louisiana was under French rule until the beginning of the 19th century, when it was bought from the US bought it from Napoleon, and so it has still has this French tradition, the idea that there's a code there, civil code of Louisiana, and so they didn't adopt it, but all the other 49 states have adopted the UCC. So this is an idea of model laws which somehow you promote, in this case, a private institution like the American Law Institute has promoted this model, and after a certain amount of years, it took about 15 years, well, finally all states adopted it. Or we find it at a more broader level, at a more global level. We have these model laws which are proposed by UNCITRAL. UNCITRAL is the United Nations Commission on International Trade Law, which is based in Vienna. And UNCITRAL proposes a whole lot of model laws which are which have to do with international trade, which can be adopted by the countries who feel this is important. Or we have this other international organization, UNIDROIT, which is based in Rome, a wonderful place in Rome, Villa Dobrandini in Rome, and over the last nearly 1 century has been well promoting first unification and now uniformity in the law, especially with its very important principles for international commercial contracts. So just to point out that there is the tendency over the last 50 years has been moving from the utopian idea of unifying the law, which is very difficult, and instead proposing for a better understanding, for a better functioning of international relations, especially in the field of private relations, well, proposing model laws. From this point of view, you should see this, we've already analyzed this when we were looking at regulation. Now, regulation has, if you go back to when we were analyzing the role that regulation has in contemporary legal systems. Regulation is a form of invasion of the state in private activities, whether it is, well, financial activity, telecommunications, transport, trading, and so on. So surely it is an intervention, and sort of the enterprises may somehow resent this, but at the same time, it gives them certainty on how to operate. They're not sure on how they should operate, and therefore having certain rules, well, if those rules are sufficiently stable, well, this means that this means that business can go on quite simply and in an orderly way. Now, if you look at this from an international perspective, and in the perspective of international business relations, the idea that there are model uniform laws simplifies relations between legal relations between parties who are in a different part of the world. A German company and an Argentinian company, an Italian company and a Chinese company. They have to do business. Obviously, the Italian company does not want Chinese law. The Chinese company does not want Italian law. Not because they distrust it, but simply because they don't know it. And therefore, you don't, no lawyer is going to accept rules that he or she does not know. So if nobody is willing to give up one's own legal system that one knows, and one knows in for better or for worse, and so having international uniform laws simplifies procedures because the parties know that that is a common ground in which they can work, and therefore this reduces what are called transactional costs. Let's write it down. Sorry, there's always a type, there's always typos here. Costs, it's plural. So the idea that when you hire a lawyer to draft the contract, obviously that is a cost in the transaction. In the transaction, you have a whole lot of costs which are related to the transaction. Obviously, what you are buying, let's imagine you're buying machinery from Germany, and you need a lawyer to draft the contract, and that is a cost of the transaction. According to how much the cost is, well, you just put it among the various other costs of the other transaction. So if you have a common ground, well, that simplifies international business relations and makes it makes them cost less. Because if you have to do sort of an agreement with Italian company has to do an agreement with a German company and has to hire, it not only has a lawyer in Italy, but has to have also a lawyer in Germany and vice versa, that is duplicating the costs. So you have to pay, instead of paying one lawyer, you have to pay two lawyers, and which makes things rather complex, because then you have an agreement not with Germany, but with Poland. And then so you need another lawyer, an Italian lawyer, and then a Polish lawyer. So that you see that the fact of having uniform laws which are agreed upon by the countries or by the parties, well, this simplifies legal relations between especially commercial parties which are placed around the world. Now, let's move on. We've seen mostly a few examples coming from private law. Now, what I would like to point out to analyze now is what we call generally lex mercatoria, or law merchant in English. I mean, two terms are, well, we use them indifferently, one or the other. We like Latin, and we obviously business, lingua franca is obviously English. Now, since the Middle Ages, you must think of the Middle Ages as a very sort of legally organized system. We generally think of the Middle Ages of very difficult and harsh times. Instead, they were very sort of lively from all points of view, both culturally and economically. Obviously, there were many problems, mostly related to lifespan and to the sort of epidemics and so on. So there was sort of average life was around 40 years old, not more than that. So, but apart from that, there was a whole lot of activity going on. And one of the main activities of the Middle Ages was sort of commercial activity throughout Europe. They were merchants that were moving, just like now, but obviously with much more difficulty, from one part or another of Europe, selling and buying, doing what any merchant has always been doing in any country. Now, what happened? These merchants that came from various parts of Europe and met generally in fairs. There were important fairs in Italy, in France, in the Flanders, in the Netherlands, in Germany. So fairs that were fixed on fixed dates, which were very important, and merchants convened for all Europe to somehow buy and sell. Now, what happened is that gradually in these fairs, merchants somehow found, when they had some kind of contrast, well, they obviously did not go, just imagine a fair in the Flanders, and you had French and German, obviously there was not nationality now as we think of it today, but you know, they were merchants coming from all around Europe, and there was no really common rules to apply. So the merchants themselves set their rules, and they to somehow regulate commercial contracts, typically buying and selling, but also renting. Just think of someone that the typical case is when you rent for a fair, you rent some premises for 1 week or 2 weeks, and then you must pay the rent, or and you don't pay the rent, or the premises are not appropriate, and so the merchant cannot put his stuff, his goods inside the warehouse. So there are commercial contracts, I repeat, mostly buying, selling, and renting. but also company law, setting up companies. At that time, they're still individual companies, and then instruments of credit. So the problem of obviously letters of credit, notes of debit, and transfer of money to financial institutions, deposits, and so on. So we have these instruments of credit. So this is how commercial law starts developing at the European level, quite autonomously from the single states, whatever the size of these nations, these sovereign nations were at that time. So we see that there is a legal system created by merchants for themselves. Next to this legal system made of substantial rules, they had also one of their typical inventions was that of establishing merchant courts. So especially in the fair, when there was some kind of conflict in the fair between sort of the sale or concerning the sale or the rent, sorry, or some other complaint between two merchants, well, there was a court there in the fair that solved the dispute. And so this is, and these judges were there not state judges, but they were judges that were designated by the traders themselves. So this is a case of private justice. So we see that starting from the Middle Ages, that means more or less 13th century onwards, throughout Europe, this lex mercatoria starts developing, and a whole body of rules come out, and which are meant to regulate at the European level certain principles of commercial contracts, commercial companies, and of instruments of credit. So this is the origin of lex mercatoria. Now let's move from the Middle Ages. Let's move to more recent times and see what has happened, because this is interesting from a comparative point of view. So what happens at the beginning of the 19th century in continental Europe, and in Latin America, we have the formalization of the lex mercatoria into commercial codes. So we see that at the beginning, starting from 1804, which is the Code de Commerce, the French Napoleonic commercial code, and then we find subsequently in Germany, in Italy, in all the Spanish-speaking countries, their equivalent. We see that these rules that were somehow have been elaborated by through the lex mercatoria by European merchants through the centuries become formalized in the law. Now, the reason of this is pretty simple from a political point of view. If you remember how the sort of French Revolution came about, well, the French Revolution was due to the fact that a certain number of French subjects, mostly city dwellers, what for that they were called bourgeois, because they lived in the towns and were mostly engaged in trade and in the professions, well, they felt that they were completely ignored by the institutions and by the state. The noblemen and the clergy were high up, and the bourgeoisie was not considered. They had no rights. And so they were the main artifacts of the French Revolution. Look who's behind the French Revolution, from who put the money, who put the men, the minds behind the French Revolution. Well, we find a great deal of French bourgeoisie. So once this class came into power, overthrowing, getting rid of the feudal system and getting into power, they said, well, now all these rules that have been private rules, we're going to make them become state rules. And so we're going to put them in a code, because once they're in the code and they have the strengths of the law, well, nobody can take these rules away from us. So this idea was made very much sense from a political point of view, and also from also from an efficiency point of view. Because what happens is that in continental Europe and in Latin America, remember Latin America means going from Mexico to Rhine, right down to sort of the Argentina, Chile. So it's a huge continent sort of that is involved in this process. This means that commercial relationships are regulated on a general broad term by the commercial code, and then the parties can decide when they want to derogate to the rules that are set in the commercial code. Well, they write a contract just establishing what is different. So you have a very big code, which is maybe 1,000 or even more articles long, which is the default rule, and the only thing you do is simply you decide that you will, what are the different rules that you want to apply to that specific agreement, which from an efficiency point of view makes lots of sense. You have background, and then you decide what you know what is going to apply, and you derogate and you start saying, well, this will not apply, or this will apply in this sense. This simplifies contract drafting, and historically, continental European contracts have been pretty short, at least compared with what we shall see in a moment. So because why they're pretty short? Because you had 1,000 articles behind you, which were somehow keeping up that contract, saying, well, if there's something that is not written in the contract, it's written in the code. So if there's any mistake, any doubt, any misunderstanding, well, we just look at the code and see what is written in the code. We know, we merchants know the code, because these rules are the rules that we have forged in centuries. So it made very much sense. And here it's interesting looking at these two models. In the Anglo-American model instead, where there's no code, where the rules were rules of trade and a certain amount of rules set out by the courts. And so the courts had somehow a rather leopard spot jurisprudence, because obviously the English and American courts had only set rules where there had been a conflict. Where there had not been a conflict, obviously they had not intervened, because courts are only for pathological cases, not for physiological cases. So what happens is that the case law in the sort of in the 19th century England and US, well, it covered a little bit, but didn't cover all the aspects of commercial relations. So merchants, businessmen, when they were drafting contracts, they said, hey, we better establish everything. We better put everything in our contract, because we don't want that somehow the court judge comes along saying, oh, but you didn't decide anything on this point. I have no precedent on this point, and therefore I cannot decide on this point. So this is why Anglo-American contracts, business contracts, started becoming longer and longer and longer. 10 pages, 20 pages, 30 pages, 50 pages, because they had to cover every aspect, even unforeseen. Why? Because you don't want businessmen, wherever, American businessmen, Chinese businessmen, Australian businessmen, Swedish businessmen, doesn't like uncertainty. He wants company, legal entity, business entity wants certainty. Certainty has a price. Okay, I'll see if that price I want to pay that price or not. But uncertainty, you don't know how much you price uncertainty. What happens if there's an epidemic? Who knows when? What will this epidemic bring along? Uncertainty obviously has very high costs. And so any reasonable businessman wants to avoid costs. So what you do when you have a business relation, you try to put everything in the contract. And so this means that drafting contracts becomes a very complex activity. This favors solicitors in the UK, big law firms in the US. Generally, the history goes that any business behind any businessman in the US, there are always at least two lawyers behind him, following the side and helping him doing whatever he has to do. So this is the lack of of a code favors very much the legal profession in drafting contracts. These contracts must be complete. They must cover everything, any circumstance, any occurrence, and all the aspects of the legal relations between the two parties. And so this becomes very complex when writing a contract. It is not simple. It is a very complex activity. Now, what happens is that when the world becomes global and international relations grow and grow and grow, well, what happens is that this model, this Anglo-American model, which seemed to continental European lawyers very cumbersome, very complex. Why must you do a 100-page contract while you can solve everything in 20 pages because you have a code behind it? Well, in the international relations, and this is why we put these ideas here, in international relations, this model of very complex international business contracts becomes the rule, the practice in the globalized world. Why? Because obviously between a Japanese company and an American company, between an Indonesian company and a German company, well, obviously nobody has a background of some kind of common rules, and so the parties decide they want to write everything. Nothing must be left to uncertainty, and so it's very specified, and so they know that if eventually there will be some kind of conflict between the parties, well, everything has been set out, and whoever is there in charge of deciding knows very well what the parties meant in that occurrence. So just to point out that this model of very detailed contracts, very minute and specific contracts has become the commonality in international business transactions. Now, what does this mean? This means that we have this new lex mercatoria. So what we have merchants, instead of being European merchants, individuals that are all flocking in a fair in the Flanders, in France, in Italy, or in Germany. So we have them in the medieval times. They all go to this place because they must buy or sell. Here we have, in this global world, we have international companies which are the equivalent of merchants of the Middle Ages, who meet together and have to find an agreement and create a new lex mercatoria. So this is why we're so interested in lex mercatoria in an international context, because we see, when we look at the international arena and we look at global business relations, we see how over the last, well, at least 30 years, if not more, 30, 40 years, there's been the establishment and growth of this international lex mercatoria, and we shall see how this is particularly important in shaping international business relations. One of these elements, if you remember what in the lex mercatoria in the Middle Ages, there were rules for contracts, companies, and instruments of credit, and at the same time, they were procedures, courts, merchant courts, where they were merchants who are elderly merchants who had experience, or people who were trusted. They were lawyers of those times who were specialized in somehow solving merchant disputes and were accepted and were called to the fairs. They were told, will you please come to the fair? So if there's a dispute, you can solve them. You are very knowledgeable and you are balanced and everybody accepts your decisions. Can you please come to our fair to solve if there are any disputes? So what happens if you transpose this from the Middle Ages, these merchant courts, you transpose them in an international arena, and you look at global business relations, we see that in all these international business contracts, there is an arbitration clause. What does an arbitration clause mean? That you submit any controversy not to the courts of a country, of a domestic of a country, whatever it could be, country of the parties or the third country. No, you send it to an arbitration, which is a private institution, which are private judges who have to decide the conflict. What are the advantages from the business point of view? Why do companies prefer arbitration courts? Because first of all, you remove the decision from domestic courts, which you mistrust. You don't, if I let's imagine there's a Chinese and an Italian company, well, obviously, Chinese company says, well, I'm not so convinced about Italian justice, so it's not corrupt, but but obviously they be more favorable to Italian company against Chinese company, and then it takes ages, it takes years before a decision is taken. So, and the Italian company says, oh, they'll go to China. Well, I've been told that, lawyers must be very friendly to the judge and bring presents to the judge, because otherwise, if you don't give presents to the judge will look at you very unfavorable. At least this is what they've told me. I don't know if it's true, but I'm not sure I want to go in front of the Chinese judge. I wouldn't trust it. So each party, and you can do this in any situation, not only between two distant countries, but it could be between near countries. Let's imagine Italy and Spain. Some say, why go to Spain? Well, so people don't like to go, businessmen don't like to go to court, and if they go to court, they don't want to have surprises. So here with arbitration, you eliminate the the risk of going in front of a domestic court, which may be biased in favor of the party which is national of that country. Then the second point is that generally in international arbitration, well, you choose the judges, which doesn't mean that the judges, obviously there are two parties to quarrel, but you will find judges who are experts and who you trust their balance and the fact that they're not biased in favor of one party or another. And then a further element, which is very important, especially for big companies, is secrecy of proceedings. These proceedings are completely secret. Nobody knows outside the arbitration tribunal, the parties and the lawyers knows what has happened. And in these contracts and in the arbitration agreement clause, well, it's very clearly stated that arbitration proceedings are strictly confidential. The whole proceeding and the award. So when the final award comes out, well, it won't be there on the newspapers because there's a confidentiality agreement between the parties. While obviously, if there is a decision taken by a court, a national court, well, obviously that is public, goes on the public record, and obviously everybody knows that someone has won and someone else has lost. So just to point out, these are the main advantages that parties business entities, big business entities which are involved in international business contracts see in arbitration clauses. So, and then one could say, hey, yes, you have an arbitration award, that's very fine, but how are you going to enforce it? When you want to enforce it, and generally when we are talking of enforcement, we are talking of some kind of damage award, which is given, some kind of parties that must pay. Well, you must somehow, if you must have enforced this decision, well, then you have to go to the state and to state courts. No, because through this next mercatoria, the whole idea is that of solving these disputes outside the sort of the control of the state. So what you do is that the parties that are involved in a business transaction, especially when the business transaction is very important, will need the backing of a financial institution. They need security, what the Americans call security, that is financial guarantees, and especially they need so-called performance bonds. What is a performance bond? It is an obligation of the bank, of a financial institution, to pay a certain sum in case another party does not perform. And so when they receive this, when the financial institution, which has been chosen by the parties, receives the arbitration award, it immediately pays. It doesn't make any discussion because he knows that it is under, it has signed a contract on the basis of which it is obliged to pay when it receives the arbitration award. So the parties can challenge that arbitration award, say, oh, I don't agree, but anyhow, the money goes from the financial institution to the party that has won the case in front of the arbitration tribunal. So you see that here you have a whole system, this international lex mercatoria, which somehow, which is mostly forged by these huge multinational, international companies to subtract any sort of activity from the jurisdiction of courts, of national courts, and to create their own legal order, which is separate from the international. So just to point out that this shows, just as the Middle Ages, merchants were trying to have their own legal system, their legal order, which regulated transaction between merchants and enforcement of judgments between merchants. Well, the same thing happens in this much bigger world, which is today's world, with international business contracts. So this is what, let's see if okay. Now, I want to just do a small stop here and just any questions on this first part of the lesson? Just to be sure, because sometimes I'm not all that convinced, when you know something, well, it's not always said that you're able to explain it. So I just would like to know if it's sufficiently clear for. Now, just to point out, this issue of international business contracts is very important, not only for those, because, well, obviously a great deal of lawyers are engaged in this. When you have an international contract, well, there are dozens and dozens of lawyers who are engaged in contract drafts. And generally, it's not only two parties. It isn't only one party that is buying, another party that is selling, but also all the financial aspects and the financial guarantees, and therefore you have to find an agreement with the financial institution. So it is a very complex operation that puts together, well, many people, obviously according to the size of the transaction, whether it is a very important transaction. Performance bond. Mariconde is asking, can you point out what performance bonds are? Now, what happens? When we must think that this has always existed, but if I'll bring our Italian students to what they are studying this semester. When you have a contract, you always put yourself the problem of performance. So what happens if a party does not perform its obligation? Buyer does not pay the price, the seller does not deliver the goods, or the goods which are delivered are defective. So what happens is, yes, you can go to court, but generally speaking, when you have a contract, especially if it is a contract, if it is a long-term contract, well, just think of a lease. You lease a house. The house is, there's a contract by which a house is leased or an office is leased, and the landlord wants some kind of guarantee. What happens if the tenant does not pay me this month's rent and says excuses, says, oh, but there's a coronavirus pandemic, I can't pay you the rent. So what you have in any contract which is of a certain substance, and especially when the contract is a long-term contract, that is, that the contract is signed today and performance is, well, much later, or somehow is a continuous contract which is lasts certain time, you always have guarantees. So the creditor asks for guarantees. Guarantees against non-performance by the other party. Now, the guarantees are under various forms. You can think, typically, when the bank gives money, a loan for the purchase of a house, two young spouses buy a house, ask a loan to a bank. The bank gives them a certain amount, but asks for a guarantee. What is the guarantee? Mortgage. So the bank has a mortgage on the house. Until the two spouses have repaid all the loan money they have received, the bank holds a mortgage on the house. And so if the two spouses do not pay the monthly or yearly repayment installments, well, the bank can satisfy its credit on the house on which it has a mortgage. Or instead, just think of a pledge, which is generally when there's an object which is given as a pledge. For example, what you do, we've seen in the case when we're looking at company law, a bank lends money to a company because the company needs money to build a new factory, to develop a new project, to do an investment, and ask for a guarantee. What is this guarantee? It says, well, you give me as a pledge, you give me your shares. So the company, which has its own shares, a certain amount, will give as a pledge for the repayment of that loan, the shares to the bank. So until the loan is repaid, the bank is there and says, well, I'll go to the shareholder meeting and I'll be sure that everything is, I'll look at the balance of the accounts and I'll be sure that everything is going well because I want to have my money back. So, and that is a pledge. And then you find financial guarantees. What are the financial guarantees? What the Americans call securities. Generally, there's a financial institution that guarantees performance of obligations. Typically, you enter a contract, and the other party says, "Well, but what happens if you don't perform your contract?" And the other party says, "I'll give you security. I'll give you." Well, that means a bank guarantee. So this means that if a party has this bank guarantee and the other party has not performed properly, the party which is the creditor goes to the bank and says, "Well, my debtor has not paid, you must pay me in its place." So this is a typical financial guarantee, and we've had these for centuries, this idea of financial guarantees. Performance bonds are a form of financial guarantee, but they are stronger in the sense that performance bonds are devoid of any formality. The bank accepts that once it has the request of the creditor, and the creditor says, "You must pay me because there are these circumstances have been fulfilled. I've asked payment of what should have been paid, let's say, within the 31st of March. I've asked it in the proper form, or rather, within the 31st of March, the counterpart should have paid me 1 million euros. Did not pay. I have requested on the 2nd of April, I've requested and said, "Listen, I'll give you 5 days to pay this sum, otherwise I will request the performance bond." The party has not answered, has not given any explanation, or has just said, "Oh, but in this moment I don't have the money." Clearly, there's an acknowledgement of non-performance of the contract by the other party. These circumstances have been fulfilled. You, bank, will ask the payment of that performance bond, and that $1 million million euros that should have been paid to me on the 31st of March, will you, financial institution, you will pay it to me immediately. So this is a very, very strong guarantee, which generally find in most international contracts, long-term contracts, because the parties want to be sure that the other party knows that it cannot escape from performance. It knows very well that if it does not perform properly, it will lose the money, because it has, obviously, it isn't, the bank is not making a gift, it's not making presents to anybody. If it pays, the bank pays the creditor, obviously it has, it knows that it will get back that €1 million, it will get it back in some other way. So just to point out that this is a performance bond, a very strong way of enforcing international contracts. We also find them in domestic contracts, but it is a typical form in which big financial institutions, American, English, Japanese, German banks are there, who are guaranteeing the position of the parties of international contract. So they are an obligation, yes, because the performance bond is a trilateral contract. There's a contract between the debtor, the creditor, and the bank. So there are three parties in this relation. The debtor tells the bank, "Listen, if these things happen, you must pay the creditor." The creditor says, "Yes, I agree, that's fine for me." And the bank says, "Yes, I agree. If I receive these elements from the creditor, I will pay within 24 hours or 48 hours. So it is a relationship, but it is not only between the two parties of the relationship. Let's imagine buyer and seller of a contract, but there is a third party, which is the financial institution, that guarantees, that provides security for performance of one of the parties. And so it is a trilateral contract between these three parties. And so there's no doubt that it obliges the three parties of this. Obviously, the debtor cannot oppose, because he has signed a contract saying, that it will pay in case it does not fulfill its obligations, and the bank knows very well that it will pay this money to the creditor, and the creditor knows it has a right. So it is much more than an obligation. It is a real contract in which between the three parties of this relation. Now, let's go back to the slides. Now, yeah. Now, what happens? Now, this is I'm bringing it on a more policy issue, which is very important because there's a lot of debate here. Very sort of, I mean, a thoughtful debate, and there's what is nice about law. There's room for everybody. I mean, you can have very different opinions, and you can confront them, and you can see what are the good arguments of certain opponents and some and those who are favorable. So, seen from the point of view of international businessmen and international companies, they say, listen, we can't, if we somehow have to do business with Argentina or with South Korea, with Australia and Russia, well, it makes it very complicated, you know, finding for each of these countries, find a legal system, understanding how it works. International lex mercatoria reduces significantly the transactional cost, speeds up procedures, because obviously you must think that if you don't draft these contracts, these big international contracts are not done overnight. They take time. It means a lot of time. It might take months, and then you must negotiate them and so on. So it is very complex. So international lex mercatoria simplifies things and favors international trade. International trade is benefit for the whole global community, because it means that it gives not only things that move from one part to the other of the globe, but people are working there. So it gives work to people. So international companies see international lex mercatoria as a benefit for everybody. What do critics say? Yes, okay, well, okay, let's take it for good that international trade is good and sort of favors lots of has also social and social benefits for all those who work around it. But, well, here there's a problem. Here we have these international, multinational. When you start saying multinational, you think of something nasty and bad. Well, these multinational companies, which are somehow, first they're avoiding taxes, so they don't want to pay taxes, so they're bad for this. So they use these contracts to reduce the amount of taxes they're paying. But then what they want to do, they want to escape from state jurisdiction, and the state authority is important. So they are trying to escape. So while common citizens, me and you, are subject to the law, well, these big companies, well, they say, well, yeah, sort of outside the law. We create our own legal order. So as you see there, and so they say, this is private lawmaking. So the law should be a monopoly of the state, or anyhow, formal institutions are the only ones who have the authority, especially setting rules and laws and creating a legal system. Here we have these huge, big companies which are creating their own rules and are somehow eliminating state control over economic activities. So you see that there are arguments, and you will find I'll put them in a very simplified way, sort of those who sustain sort of international lex mercatoria is good and those who sustain that the international lex mercatoria is bad. But just to show that this is a very heated debate, and the core of the problem is this idea: if lawmaking can be somehow outsourced to private entities. Now, this is not a theoretical issue, because I'll bring you here two examples, very common examples, which come from the financial sector and the digital technology sector. Let's set aside the financial, but this is, maybe we'll come back to that when we're looking at the World Bank. But if we look at the digital technology, when we have all this debate, I don't know if you're aware of this, or maybe you've heard of this debate about the GAFAM: Google, Amazon, Facebook, Apple, and Microsoft. These 5 big tech companies who are set the rules around the world, bigger than, sort of, if you put them all together, they're bigger than many states by themselves, and they're doing the private rules. So Facebook decides what is obscene and decides whether a certain speech can be made on its Facebook account, and what you can do and what you cannot do. And Google will remove content which someone claims it violates copyright. So that somehow these big companies are somehow private companies, have become the sort of the policeman of the network of the internet. So just to point out that this is, I'll put it in a rather simplified way, but you see, this has to do very much to do with private lawmaking. To what extent can these companies somehow regulate what is activities of individuals on these platforms? It's interesting, there are decisions that were taken in the US, then there were found some decisions taken in Europe, there was a decision taken in Italy, and then it was reversed on appeal by an Italian court on the fact that Facebook and Twitter are what we call public arenas, and places where, as if they were squares. When you go in a square, town square, and I go in there and I hold a placard saying, well, I'm against this or that, I'm in favor of this or against that. And so I have freedom of speech in a public arena. So when I go in a public square, I express my views, and I have the right to express my view, and nobody can prevent me from expressing my views, provided obviously they're not, so they don't violate laws which are very clearly stated out, let's say obscenity, or something that I'm inciting sort of criminal activity, saying put a bomb under the mayor's seat and sort of kill so and so. But if I don't go to these extremes, I can easily speak, do what I want, and I can express my views. And nobody can prevent me from doing it. This tradition, which now has been completely forgotten in digital ages, so-called Speaker's Corner in Hyde Park in London, where originally, when there was obviously there was no digital, there wasn't Facebook, there weren't platforms. Well, someone went there in the Speaker's Corner and could say whatever he or she wanted in favor or against this or that. Now, it's interesting because we see this when we look at the digital arena. We see that this is there's a very nice case cited by the Southern District of New York Federal Court, Southern District of New York. So what happened? If you know how Twitter works, you have a Twitter account, you send a message, and then you have people who somehow respond to your message, or repeat your message and send it further on. Now, As you know, President Trump, the US president, is a great lover of Twitter. And substantially, what he does, he first sends a Twitter message and then he takes an executive order. So the problem is whether his Twitter messages are the equivalent of executive orders. And this, the constitutionalists in the US have been wondering if they are substantially, if they are, what is the value? So what happened? That certain number of opponents of President Trump entered the Twitter account and were receiving the messages and then were immediately responding and very fiercely responding to what President Trump was saying. Very strong opponents of President Trump. So President Trump, who said, well, this is my Twitter account, the real Donald, just that's his account, the real Donald, just to avoid mistaking, if you would mistake someone else. No, the real Donald, to that account. And so they were somehow responding immediately. And so all their messages went to all the followers of Donald Trump. Donald Trump was quite, from his point of view, quite rightly annoyed by this fact because he was speaking, he's the president of the US, and he doesn't want people somehow to say, well, if they want to disagree, well, they have a whole lot of other forum. They can set up their own Twitter account and express their views on their own Twitter account, but not on his, the real Donald Twitter account. So what he did, he asked Twitter to kick them out, to say, I don't want so and so, so and so. You must take them off this Twitter account. These people were expelled from the Twitter account of Donald Trump, and they went to court, and the court, U.S. federal court in Manhattan, said, sorry very much, Mr. Trump, but when you engage and you go on Twitter, it's just like if you went in a public square, and anybody can, if you are on you're doing a meeting, a rally in a public place, and you're saying certain views, anybody can come there and say, I'm not in agreement, and shout and yell and challenge what you're saying. So Twitter is a public space where anybody can go. So just to point out what happens, here we have a space which is created by a private company, Twitter, and it is somehow, it is what rules do we apply? Should we apply the rules of Twitter, which says, well, if you behave badly, I will shut you out, or shall we apply ordinary legal rules? So just to point out that this issue of sort of private lawmaking is very complex, very lively in the high-tech, digital tech context and platforms, on to what extent Google, mostly Google, Facebook, and Apple can somehow bar, and obviously all the other applications, it is Telegram or the other platforms, if they can apply their own private rules, or are they subject to the laws of various countries. So just to show that this issue of private lawmaking is not is a very sensitive issue, and it grows because we are talking of international actors. Google, Facebook, Apple, and Amazon, and Microsoft are international companies, and so what law do we apply to these to this activity when Google is operating in Australia, in Japan, in Argentina, in Botswana, or in Paraguay? I mean, it's complex understanding if they should apply only the rules they have set, or the rules of the country where they are operating, if you can establish that they're operating in a country when we're talking of digital, of immaterial, non-material activity. So just to close this point is that we see, if we look at the situation today, we have two opposite tendencies. On the one hand, we have states who tend to expand their sovereignty. Just think of treaties in concern the high seas or the outer space. So places where they do not have states, do not have sovereignty, but they try to set rules that regulate in these spaces, physical spaces, which are not under their control, their traditional control, which it concerns the borders of a country, in the sky of another country. And so nations are trying to expand their sovereignty, and on that other side, we find that more the nations try to expand their sovereignty, we find these big private companies which try to avoid and to escape from this national sovereignty through private law agreements, which are next mercatoria in first hand, but also through these general terms and conditions. If you go, if some of you somehow, as you are young law students, if you go on the platform that you're using, whether it's Facebook or Google, everybody uses Google, and or Amazon, so on, and sort of goes on the terms and conditions, which are right down written, very small print. Just remember, if anybody of you is Donald Duck and Uncle Scrooge, and Donald Duck always signs a contract which is presented to him by Uncle Scrooge, and at the bottom there's a small fine print, there's a clause, and there's always a magnifying glass that shows that there's a clause that says certain things which are against Donald Duck. So if you look and don't want to be like Donald Duck, because obviously these big companies are more or less like Uncle Scrooge, and you read these terms and conditions which are written in very fine print, well, you can start thinking and saying, wondering, well, what is the kind of, when you do a research on Google, when you open an account on Facebook, when you send messages, tweets on Twitter, well, what are the terms and conditions which regulate your activity? So this is just to show how important private law making is in the international field and international relations. Before moving to the next point, which is equally important, I just wanted to ask you if there are any questions on this, what we've been doing, seeing now, sort of private law making. I lost everybody? Okay, I'm just going to start this further part, which needs to be, I'll conclude it obviously tomorrow. International organization. So we have this further element in international law. Remember, we were looking at international law as relationship between states, then relationship between states and individuals, or between individuals at a global level. And then we're looking at international organization. And so we have seen over last centuries that there's been always the attempt of keeping world order. World at that time was small. I mean, you must think of Europe mostly. We're talking Western legal tradition, so we're mostly concentrated in Europe, and then suddenly, well, obviously after the American Revolution, there's also the United States of America, but mostly in Europe, well, trying to keep peace through legal instruments. Whether we look at the great lawyers and philosophers of the sort of from the 16th to the 18th century, whether it is Grotius, Leibniz, or Kant, they always sort of we're talking of huge people of immense personalities which have shaped not only the law but the way we think. I mean, Leibniz was a total genius. He was a mathematician, he was lawyer, he was diplomat, he was a whole lot of things together. And obviously Kant provided us with a whole lot of ideas from which we still try to understand the world and how we as humans understand what is happening in the world, what is outside of us. So the idea is that the law somehow is the guarantee of peace. So if the law, in as much as the law settles relations, establishes what are the duties, obligations, rights of parties, well, and we bring this obviously to international level, well, this will be a peaceful world because nobody wants war. Nobody wanted war 5 centuries ago. Nobody wants war today. So, so legal instruments are seen as somehow guaranteeing peace. Now, this generally happened through bilateral relations between countries. Mostly, they had bilateral relations. We find some cases of multilateral agreements. Just think of how the Swiss Confederation came out, or further, how the US, the 13 colonies, decided to join together and to fight the British and to conquer their independence. But what is, when we look at the history of international organizations, we see that they start developing always in the second half of the 19th century. And then, but we have some, there are mostly these conventions exist. And then there's an attempt to have international organization. Because a treaty is a treaty, and then the parties of the treaty somehow, the parties of the treaty then keep this treaty in function. But in international organizations means that there is an organization. Therefore, there's someone there, an organization that is there to promote and to put into place what are the sort of principles established in this treaty. So we find that these international organizations start slowly towards the end of the 19th century. Then they are developed after World War I. World War I is dramatic, a failure of liberal ruling classes. I mean, all these countries that were involved in the First World War, France, Great Britain, Germany, Austrian Empire, Italy, were all somehow governed by liberal, quote unquote, ruling classes. I mean, educated, and so that they they were not despotic. Obviously, they were not they were not democratic countries yet, but they were sort of open to social needs and so on. And they went and entered like that into this World War I, which was butchery, and sort of millions of people killed around Europe for frankly no reason whatsoever. I mean, they could have been easily solved through negotiations. Instead, they all entered into this world war. So after this failure of what happened of sort of peacekeeping in the World War I, well, this attempt, which is mostly favored by the U.S. president of that time, Woodrow Wilson, creating this, who was an outright sort of peacekeeper, this creation of the League of Nations, which was, well, had more or less about 50 member states, and the sort of the whole scope was that of preserving peace. It didn't preserve peace and was just swept away. First, when think that in Europe dictatorships sprung up. Italy first came, and then most of other European countries followed. Very few countries remained outside this. France, Great Britain, Belgium, Netherlands, Scandinavian countries, but then all the rest of Europe fell under right-wing dictatorships through the 20th and the 30th. So, well, that was World War II. So there was no League of Nations was swept away. What happens after World War II? Something completely new happens, and we see that, and this is what we will start discussing. Tomorrow, the United Nations Organization. And why we're so interested in looking at the United Nations Organization. We will not enter into detail, but we are interested to see how we try to create rules, laws, international treaties in order to ensure peace, prosperity, progress, development, and a whole lot of other values. So we are particularly interested as lawyers to understand what has happened starting from when the UN was created in 1945, that is 75 years ago, and so what has happened and how the system, what has done, what it has not done, what it means obviously for us lawyers, because there are other perspectives which are international politics and other perspectives which are equally important. Here we will focus on the legal aspect, but we'll talk about this tomorrow. Before closing, any questions? Can I just ask those who joined the conference lesson after 4:05 just to put their names down, because I didn't have time, obviously, to write them down.